Hey guys, it's Professor Joe's coming to you today to talk to you about legal and ethical issues in relation to the older adult. So let's start by talking about professional standards. Nursing standards of practice are measured according to the expected levels of professional practice of those in similar roles and clinical fields. A standard of practice is a guideline for nursing practice and establishes an expectation for the nurse to provide safe, effective, and appropriate care. It is used when we evaluate whether care administered to a patient meets the appropriate level of skill and diligence that can be reasonably expected given the nurse's level of skill, education, or experience. Standards can originate from several different sources. Sometimes these standards are established at a state or a federal level. When institutions conform to state, local, or federal standards, as well as compare or benchmark with other similar facilities, this is considered evidence of proper care. Some jurisdictions in the U.S. call this community standard of care. The published standards of professional organizations representing the opinion of experts in the field are important in establishing the proper standard of care. One example of this is the scope and standards of gerontological nursing practice, originally established by the American Nurses Association, or the ANA, and most recently revised in 2010. When it comes to accreditation, most organizations at some point will seek accreditation. This means that the organization undergoes a voluntary, detailed survey by the accrediting body that has expertise and skills to evaluate these organizations. The most well-known accreditation organization is the Joint Commission, formerly called the Joint Commission on Accreditation of Healthcare Organizations, or JCAHO. Now you will see it abbreviated as TJC, the Joint Commission. The standards established by the Joint Commission to review healthcare facilities are often referred to in court cases to ascertain the appropriate standard of care. Federal and state statutes require nursing facilities to have written healthcare and safety policies, and these have been used successfully to establish a standard of care in court cases. Bylaws and internal rules and policies within the organization also help to establish the standard of care within an organization, although, depending on the circumstances, their importance may vary. In any event, it is important for nurses to be aware of their organization's policies. Failure to follow your own rules clearly possesses a liability risk, both on the nurse and the organization. So let's talk about an overview of relevant laws. Statutes are laws created by legislators and are enacted at the federal and state level. Regulations are rules of action and conduct developed to explain and interpret statutes and to prescribe methods for carrying out statutory mandates. The regulations are promulgated or made known at the state and federal level. Centers for Medicare and Medicaid Services. These provide regulatory oversight, and Medicare pays for skilled care. This includes things like nursing, physical therapy, occupational therapy, and speech therapy for Medicare-insured persons that are in long-term care facilities. Medicare pays for both intermediate and skilled care for people who are indigent. So let's talk for a minute about the Older Americans Act. This act requires states to mandate a minimum bureaucratic system to perform various services for older adults. The Older Americans Act was born in 1988 and increases the state's responsibility for maintaining an effective long-term care program. Essentially, they receive and resolve human and health service complaints affecting residents that are in nursing facilities. Changes in federal law provide additional protection to individuals and their families when they need to buy, change, or continue health insurance coverage. The Health Insurance Portability and Accountability Act of 1996, also known as the HIPAA Act, increase a person's ability to get healthcare coverage when they begin a new job. It also lowers the chance of losing existing health coverage, can help maintain continuous health coverage when there is a change of jobs, and helps purchase health insurance coverage individually if the coverage is lost under the employer's group health plan and no other health coverage is available. So specifically, it limits the use of pre-existing condition exclusions. This prohibits group health plans from discriminating by denying coverage or charging extra coverage based on a person's or a family member's past or present poor health. Guarantees certain small employers and individuals who lose job-related coverage the right to purchase insurance. It also guarantees in most cases that employers or individuals who purchase health insurance can renew the coverage regardless of any health conditions covered under the health insurance policy. Let's talk about older adult abuse and protective services. So obviously we've already determined that the incidence of illness and disability increases with age. As we age, and health declines, this often leads to changes in living environments. These changes not only affect the older adult, but often their family and others who must see to their care and living needs. So without enacting appropriate interventions and resources, this can lead to neglect, deliberate abuse, or exploitation of older adults. Incidents of elder abuse are likely grossly underreported. As a matter of fact, elder abuse, including neglect and exploitation, is reported to be experienced by 1 out of every 10 persons age 60 and older. Elder abuse is defined by state laws, which vary from state to state. However, 3 basic categories of elder abuse do exist: domestic elder abuse, institutional elder abuse, and self-neglect or abuse. So domestic abuse is forms of maltreatment by someone who has a special relationship with this older adult. This could be a family member, a caregiver. Institutional abuse is defined as abuse that occurs when you are a resident within an institution, such as a nursing home, or someone who is a paid giver, perhaps in the home. And then finally, self-neglect is usually related to a diminished physical or mental decline. It is identified by a failure or refusal to provide oneself with adequate shelter, food, water, hygiene, safety, clothing, or health care. An analysis of existing definitions inclusive of elder abuse, neglect, and exploitation was conducted by the National Center of Elder Abuse, the NCEA. 7 types have been identified. Physical abuse accounts for the use of physical force that may result in bodily injury, physical pain, or impairment. Sexual abuse refers to non-consensual sexual contact of any kind with an older person. Emotional abuse would be the infliction of anguish, pain, or distress through verbal or nonverbal actions. Financial and material exploitation includes illegal or improper use of an older adult's funds, property, or assets. Neglect is the refusal or failure of a person to fulfill any part of his or her obligation or duty to an older adult. Abandonment is desertion of an older adult by an individual who has physical custody of the older adult or by a person who has assumed responsibility for providing care to the older adult. Finally, self-neglect are behaviors of an older adult that threaten the older adult's health or safety. So what are the nursing implications? Elder abuse generally occurs as a result of many complex factors. So, for example, caregiver stress or lack of supportive resources resulting in depression or burnout. Nurses need to be alert and able to recognize these signs and symptoms of abuse. Obviously, some are much easier to spot than others. Most states designate certain professionals, such as nurses or other caregivers, as mandatory reporters, making it requirement by law to report suspected cases of abuse, neglect, or exploitation. Failure to report may result in civil penalties, criminal penalties, or both. The term Adult Protective Services refers to the range of laws and regulations enacted to deal with abusive situations. The laws and regulations are typically administered by an agency within the state. For example, the Department of Social Services, an individual state's Department of Health, which receives and investigates complaints. So let's answer the question here. The nurse is working at a health fair and notices an older gentleman with his son. The older man appears to be in need of a haircut. His clothing is soiled and torn. However, the son's clothing is clean and fresh. The nurse suspects that the older man may be a victim of which type of abuse? The answer is B, neglect. Due to widespread evidence of resident abuse in nursing homes, a landmark piece of legislation was passed, the Omnibus Budget Reconciliation Act, or ORBA, O-R-B-A. ORBA applies to all Medicare and Medicaid certified nursing facilities, including acute care facilities. Evidence that the health and safety of nursing facility residents has improved as a result of these stringent regulations and sweeping reforms. Such improvements amount other things, including reduction in the overuse of antipsychotic drugs, inappropriate restraint use, and inappropriate use of indwelling catheters. This was achieved by increasing the number of penalties on poor quality nursing facilities providing substandard care. Quality of care means that residents must be assessed to detect medical problems, evaluation of their capacity to perform daily life functions, and identification of significant impairments in their functional capacity. In Medicare and Medicaid certified long-term care facilities, physicians evaluate residents at the time of admission. Then a reassessment must be completed by a provider at 30 days, 90 days, and with any change in condition, and at 1-year intervals. The state-specified instrument used to conduct the initial assessment is referred to as the minimum data set, which you'll see abbreviated MDS. Resident rights must be disclosed to patients and families in writing and orally at the time of admission. This is usually done with a resident bill of rights or an admission agreement. ORBA regulations require nursing facility residents to be free of unnecessary drugs of all types, chemical restraints, commonly thought of as psychotropic drugs, and physical restraints. Chemical restraints are inclusive of drugs used to limit or inhibit specific behaviors or movements such as antipsychotics, benzodiazepines, and other sedative drugs and hypnotics. If a resident does require some type of antipsychotic, there must be a documented indication such as schizophrenia, different types of psychosis, or Tourette syndrome. These drugs should be used for behaviors, these drugs should not be used for behaviors such as restlessness, insomnia, yelling or screaming, and wandering because of the staff's inability to manage the resident. More than half of all nursing facility residents are incontinent. If left untreated, this condition can lead to other problems such as infection and skin breakdown. Because of this, nursing facilities are required to include incontinence in the comprehensive assessment of a resident's functions and provide the necessary treatment, inclusive of bladder retraining, prompted voiding, and pelvic floor exercise. Facility survey and certification. So what does this mean? Well, standard annual survey is done to review the quality of care. If care is substandard, the facility may be given an extended survey. The Department of Health and Human Services and the state may apply sanctions or penalties for failure to meet requirements and standards. Such sanctions include civil monetary penalties, appointment of a temporary manager to run a facility while deficiencies are remedied, or even closure of a facility and transfer of the residents to another facility. The Affordable Care Act was passed by Congress and signed into law in March of 2010 by then President Barack Obama. It is often referred to as Obamacare. The Affordable Care Act, or ACA, you'll see it abbreviated as, represents the largest change to the U.S. healthcare system since Medicare and Medicaid began in 1965. The main goal of the Affordable Care Act is to reduce the number of Americans who do not have health insurance and to further reduce the overall cost of healthcare in the United States. All Americans will be able to maintain health insurance regardless of their community rating, pre-existing medical conditions, or age. Everyone within the same age group and location must be charged the same premium. Failure to secure coverage may lead to penalties assessed by a health insurance tax. So let's talk about autonomy and self-determination. The right to self-determination is based on the doctrine of informed consent. Competent individuals are provided with information that enables them to make decisions about treatments or interventions that will be performed on them. Competent basically means one who is able to understand the proposed treatment or procedure and thereby make an informed decision. The right to self-determination covers all decisions about one's care and treatment, including removal of life support or life-sustaining treatments, and life-prolonging or life-saving measures. These issues are particularly relevant to the older adult. Although individuals of all ages are concerned with these matters, and young people do die, incapacity and infirmary are more common in old age. Therefore, more frequent discussions of the need to preserve the right to self-determination occur among older adults. A do not resuscitate order is a specified order from a healthcare provider entered into the patient's medical record. The order instructs healthcare providers not to use or order specific methods of life-saving therapy, usually referred to as CPR. This generally includes therapies to restore cardiac function or to support ventilation in the event of cardiac or respiratory arrest. Again, remember, for persons to choose to accept or reject medical care, that person must be determined to be competent. The Advanced Medical Directive is a legal document completed by the patient that communicates the general wishes of the individual regarding treatment wishes after a medical emergency. It is the patient's responsibility or the patient's family's responsibility to provide a copy to healthcare professionals. This document can then aid and guide healthcare professionals when making treatment decisions if a person becomes incapacitated. The living will is a written testament by a competent patient outlining what they want in the event of a terminal illness or condition. They are not effective until the patient becomes incompetent. The durable power of attorney for healthcare, you'll see it abbreviated DPAHC, is a legal instrument by which a person may designate someone else to make healthcare decisions at a time in the future when he or she may become rendered incompetent. The role of the designated surrogate or durable power of attorney is to make decisions that most closely align with the patient's wishes, desires, and values. A durable power of attorney does have an advantage over the living will in that the designated power of attorney for healthcare may assess the current situation, ask questions, and gather information to assist in determining the probable wishes of the patient. The living will, however, speaks for the patient who cannot speak for him or herself. So what happens when there are conflicts between patients' directives and family desires? Well, laws uphold and express the desire of a patient over those of the family, but the family can exert influence that is sometimes contrary to the wishes that were expressed by the patient. So, should conflict occur, most medical directive statutes specifically provide immunity for physicians who follow in good faith the wishes of the patient. Now, nurses should note in most cases this immunity applies only to the physician and not to the nurse because the physician is given the legal duty to put into effect the patient's wishes. The Patient Self-Determination Act of 1991 is the intent of this law is to ensure patients are given information about the extent to which their rights are protected under the state law. Basically what this does is it requires hospitals, nursing facilities, or other healthcare providers who receive federal funding to give patients written information explaining their legal options for refusing or accepting treatment should they become incapacitated. There's clear and convincing proof of this. So the Cruzen case of 1983 was a 25-year-old female who was involved in a very awful motor vehicle accident, and she survived and persisted in a vegetative state. 7 years after the accident, her parents, who were designated her co-guardians by a court judgment, sought a court order to withdraw artificial feeding and hydration. In 1990, a 5-4 decision by the United States Supreme Court held that because there was no clear and convincing evidence of the patient's desire to have life-sustaining treatment withdrawn under such circumstances, that her parents lacked the authority to carry out this request. 4 significant provisions of the Patient Self-Determination Act. Well, they require maintenance of written policies and procedures, guaranteed that every adult receiving medical care be given written informed information regarding their involvement in treatment decisions. Providers must offer education to staff and the community on issues concerning advanced medical directives. States are required to develop a written description of the law concerning advanced medical directives and distribute the material to providers. Secretary of the Department of Health and Human Services is required to develop and implement a national campaign to inform the public of the option to execute advanced medical directives and their right to participate in and direct healthcare decisions. So what are the nurses' responsibility? Well, according to the American Nurses Association, nurses should know the law of the state in which they practice and should be familiar with the strengths and limitations of the various forms of advanced directives. The nurse has a responsibility to facilitate informed decision-making, which includes but is not limited to advanced directives. So looking at the Cruzen case, it took place in Missouri. Most states have not adapted this rigorous standard of proof for decisions regarding life-sustaining decisions. In most jurisdictions, family members, those close to the patient, or a surrogate decision maker can make the decision for a patient that has left no specific oral or written instruction. Regarding values history, there are instruments that ask questions related to quality of life versus length of life and tries to determine the values a person sees as important to maintain during times of terminal care. These are good to establish a patient's wishes before it is far too late. When it comes to ethics, ethics relate to the moral actions, behavior, and character of individuals. Nurses occupy one of the most trusted positions in society, and conforming to a code of ethics gives evidence of acceptance of that responsibility and trust. A code of ethical conduct offers general principles to guide and to evaluate nursing actions. The role of the healthcare professional is to advocate, promote, and improve patient autonomy, maintain or improve health status, and to do no harm. The nurse-patient relationship is built on trust, and nurses' understanding of the key ethical principles is the basis of a trusting relationship. The key ethical principles should serve as a framework for nursing decision-making and application of professional judgment. The key principles are listed here: autonomy or self-determination, beneficence, meaning to do good, non-maleficence, meaning to avoid evil, justice, the allocation of resources, and veracity, which is truthfulness. Experimentation and research. Patients may refuse to participate in experimental research and may refuse to be examined, observed, or treated by students or other staff who jeopardize their access to care. When it comes to ethics committees, the primary objective of an ethics committee is to carefully evaluate differing positions to achieve a consensus that is ethically and legally acceptable to all patients. So essentially, their job is to resolve conflict that might otherwise force treatment decisions to the courtroom. The main purpose is to create a forum where patients, patient representatives, and other providers can express and consider different points of view. Ethics committees do not have any legal authority. That's it for this week's discussion. I hope you enjoyed.